Good afternoon. This is Sean Golding with Golding and Golding, here to discuss a very common question we receive, which is whether taxpayers who are permanent residents or have other opportunities to become a U.S. citizen should actually become a U.S. citizen. There's two main components, immigration and tax, so let's get to it. Immigration, right? U.S. citizenship does provide lots of benefits from an immigration standpoint. One, it's easier to travel in and out of the United States. You don't have to worry about them checking whether you've been in the U.S., how long you've been in the U.S. for. It helps to avoid things like an involuntary termination. Let's say you've been out of the country for 9 months or over multiple years for several days, and you can't show that you've been living in the U.S. sufficient, and you don't have a reentry permit, or maybe you had a reentry permit, but you can only renew it a few times, and now you're not able to do it again. This becomes a problem, especially for people who may have a reentry permit, but it expired. Then they want to come back to the U.S. because you typically have to do it from the United States to apply for a reentry permit, and then you can't get back in because at the port of entry they say, "Hey, you've been out for a long time. Give me that." Uh, it also avoids or minimizes the issue of deportation and removal, right? You get pulled over, you get in some trouble, maybe a small criminal case. If you're on a green card or you're a visa holder, L1, H1B, or maybe you're a citizen but your children are on visas or vice versa, it could become an issue. Whereas once you're already a U.S. citizen, the chances of deportation or removal are much less. Even if it was by birth, lineage, naturalization, it doesn't really matter. It's much harder to force a citizen out of the country than it would be to um, force or deport or remove a green card holder or other resident. One of the main deterrents to becoming a U.S. citizen are the taxes and the reporting. Unlike almost every other country across the globe, the United States follows a citizenship-based taxation model. What that means is if you're a U.S. citizen, even if you're a permanent resident or a visa holder that meets the substantial presence test and doesn't qualify for any exceptions or exclusions, the U.S. taxes you on your worldwide income. So let's say you're a U.S. citizen and you're living overseas, and all of your income is sourced from overseas. Maybe you're in retirement, you're getting superannuation, or you work overseas and you work in a low tax jurisdiction, and you earn more than the foreign earned income exclusion would exclude. You can get taxed on that income even though you, one, are not a resident of the United States, and two, your income is not sourced in the United States. Now, if you happen to be in like a high tax jurisdiction like the UK, Australia, Canada, you get foreign tax credits, right? So if you're earning a lot of money overseas, but you're paying a lot of tax overseas, you could typically take those credits against your U.S. taxes on the foreign income, and it'll typically bring it down, or if not, eliminate it completely. Also, the foreign earned income exclusion and housing exclusion, which basically says each person who qualifies having their tax home in a foreign country and either the bona fide residence test or the physical presence test can exclude upwards of $120,000 of their income in addition to some housing expenses. So feasibly, two people who file jointly live overseas, each earn $120,000 a year and rent a home. They may not have to pay any U.S. tax. Now, they do have to file. So you'd still file your tax returns, but then you would claim 2555. It's important to do so. Otherwise, the IRS doesn't know that you're qualifying for this. And if you haven't applied for foreign tax credits, it could lead to significant tax liability, which could lead to passport revocation. That is something, there's a ton of ridiculous fear mongering you'll find online, but in reality, passport revocation is becoming more common. In addition to the taxes, there's also reporting. The U.S. requires taxpayers who are citizens, and again, if you're a permanent resident or resident that meets the substantial presence test, you have to report your foreign accounts, assets, investments, and income. So your foreign bank accounts, your savings accounts, your NROs, NREs, your fixed deposits, your current account, your savings account, investment accounts, stock accounts, pooled fund accounts, mutual funds, ETFs, CCOVs, pension plans, retirement, life insurance, and it goes on. But these accounts all have to be reported, and there's various different international information reporting forms that you may have to file on. The two that you see very often are the FBAR and Form 8938, which is FATCA, the Foreign Account Tax Compliance Act, but there's many other forms as well. Forms 3520 for gift and trusts, 3520A for trusts, 5471 For foreign corporations, 8865. For partnerships, 8621. For foreign mutual funds, 926. And there are some other ones as well. 5472 you may see as well, but that's for non-U.S. persons who have U.S. companies. If you are a citizen, and we'll get to this in a minute, but if you're a citizen and you live overseas, you don't qualify for the same treaty elections. There's currently a case now, I think it's ROS Day, where the lower court agreed that if you're overseas and you make a treaty election to be treated as a foreign person for tax purposes and don't waive the benefits, that you don't have to file at least the FBAR, maybe other international reporting forms as well. Once you become a citizen, this doesn't apply. So let's go through some of the cons now, right? The treaty election we were just talking about, this is a major concern for people who become U.S. citizens. And let's use Australia as an example. So if you're a green card holder, you're living in Australia, and you're receiving a significant amount of superannuation, let's say. With the supers, we have lots of resources on supers, but typically, while they're similar to 401ks, they're not identical. You don't typically get taxed at distribution. It's taxed while it's growing. So let's say you're getting a $200,000 distribution a year superannuation. If you're living overseas as a green card holder, you could, make a treaty election to be treated as a foreign person for U.S. tax purposes and feasibly avoid having to pay U.S. tax on the superannuation. If you're a U.S. citizen and you're living abroad, you typically can't make that same election. So you may have a significant amount of tax liability that you wouldn't otherwise have if you weren't a U.S. person. And so while the immigration benefits, pros are there, easier to travel to see your kids, your grandkids in the U.S., or to come here a few months out of the year without having to deal with the hassle of immigration. The con is that you may be paying a significant amount of tax. Another very substantial con for some taxpayers is the exit tax. If you are a U.S. citizen or long-term lawful permanent resident, depending on how much income you're earning each year, your net effective income tax, your asset values, things like that, you could be subject to substantial exit tax. If you're a citizen, it's very hard to get around. When you're a green card holder, you could plan for it easier. And the way you do that is that if you're living overseas, you make treaty elections to be treated as a foreign person for tax purposes. Any year that you're treated as a foreign person for tax purposes is not counted toward the 8 of the 15 years for a long-term lawful permanent resident. And another significant consequence can be some countries do not allow dual citizenship. Like Singapore, I think once you're over a certain age, 22, 24, you can no longer be a dual citizen. So some people may want to have dual citizenship, but if you're from Singapore, for example, you don't want to give up your Singaporean citizenship, right? Something to keep in mind. And there's also the tax implication, which is if you are a Singaporean citizen, and let's say you have CPF, and you give up your Singaporean citizenship, then they may not allow you to keep your CPF. Sometimes they do, sometimes they don't. It depends on the kind of investment you have and what your status was, permanent resident versus citizen. So there could be a very significant tax implication because there's no treaty with Singapore. For taxpayers who are considered U.S. persons, U.S. citizens, lawful permanent residents, foreign nationals who meet the substantial presence test, if you're not in compliance for reporting your foreign assets, accounts, investments, and income, you may be subject to fines and penalties, but there's many different programs to assist you with getting into compliance. If you're willful, then the VDP is really all you could do. Voluntary disclosure program is for people who are willful. There used to be a separate offshoot of that program, OVDP offshore. Now it's all mixed together in one bag called the VDP. VDP has been around forever. If you're non-willful, there's a lot more opportunities available. There's the streamlined filing compliance procedures, domestic and foreign. Both of them are for offshore foreign accounts. Just domestic means you're a U.S. person, 5% penalty. Foreign means you qualify as a foreign person or foreign resident, and then you get the penalty waiver. There's also the delinquency procedures and reasonable cause. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.